Q1, Q4, Q2 and personal transactions. While both aim to protect parties from potential losses or defaults, their purpose and legal consequences. A contract of indemnity involves a promise to compensate for loss, whereas a contract of guarantee ensures the performance of an obligation by a third party. Understanding these distinctions is vital for legal practitioners and students alike, as they influence the rights and liabilities of the parties involved. Description explanation. Contract of indemnity. Defined under Section 124 of the Indian Contract Act, 1872, a contract of indemnity is an agreement where one party, the indemnifier, promises to save another party, the indemnity holder, from loss caused by the conduct of the indemnifier or any other person. It is a bilateral contract aimed at compensating for actual or anticipated loss. For example, an insurance policy is a common form of indemnity where the insurer agrees to cover losses due of guarantee. As per Section 126, a contract of guarantee is a tripartite agreement where the surety promises to perform the obligation or discharge the liability of a principal debtor to a creditor if the debtor defaults. Nature of liability. Nature of liability. In indemnity, the indemnifier's liability is primary and arises directly upon the occurrence of loss. In guarantee, the surety's liability is secondary, triggered only by the principal debtor's default. Purpose. Indemnity aims to compensate for loss suffered. Guarantee secures the creditor against the debtor's non-performance. Commencement of liability. Indemnity liability begins when the indemnity holder incurs a loss. Guarantee liability arises only upon the debtor's default. Number of contracts. Indemnity consists of one contract between the indemnifier and indemnity holder. Guarantee comprises three implied contracts, between the surety and creditor, surety and debtor and creditor. Request of parties. In indemnity, the indemnifier acts independently, not necessarily at another's request. In guarantee, the surety typically undertakes the obligation at the debtor's request. Sections of related law. Section 124 defines a contract of indemnity as a promise to save another from loss. Section 125 outlines the rights of the indemnity holder to recover damages, costs, and sums paid under the indemnity. Section 126 defines a contract of guarantee as a promise to perform or discharge a debtor's liability in case of default. Section 127 states that anything done or promised for the debtor's benefit can be sufficient consideration for a guarantee. Section 128 establishes that the surety's liability is coextensive with the debtor's unless otherwise provided. Case laws with examples and elaborated explanations. Adamson v. Jarvis, 1827. Facts. An auctioneer sold goods on behalf of a principal who had no authority to sell, leading to a lawsuit against the auctioneer by the true owner. The principal promised to indemnify the auctioneer for any loss. Decision. The court held that the auctioneer could recover losses from the principal under the indemnity contract, as the loss arose from the principal's actions. Explanation. This case illustrates that an indemnity contract activates when loss occurs due to the indemnifier's conduct or instructions, emphasizing the primary liability of the indemnifier. It clear promise. Unlike indemnity, the involvement of a third party, debtor, necessitates clarity in the surety's. Kalashnath v. State of UP, 1968. Facts. A contractor faced losses due to government actions and claimed indemnity based on an implied contract arising from the circumstances. Decision. The Indian court recognized an implied contract of indemnity, allowing recovery of losses. Explanation. This case demonstrates that indemnity can extend beyond express agreements, focusing on loss compensation. It contrasts with guarantee, where the surety's role is explicitly tied to a debtor's default, not an independent loss event, reinforcing the bilateral versus tripartite distinction. Bank of Bihar Limited v. Damodar Prasad, 1969. Facts. A bank, as creditor, sued both the principal debtor and surety for a loan default. The surety argued limited liability. Decision. The Supreme Court held that the surety's liability is coextensive with the debtor's under Section 128, unless restricted by the contract. Explanation. This case exemplifies the secondary nature of a surety's liability in a guarantee, activated on litigation of legal disputes and commercial arrangements, making them indispensable in contract law studies. Memory aids. Table. Indemnity versus guarantee. Feature. Indemnity. Guarantee. Parties. 2. 3. Liability. Primary. Secondary. Purpose. Loss compensation. Debt security. Contracts. 1. 3 implied. And co-sureties, ensuring a comprehensive response for maximum marks. Introduction. A contract of guarantee of the Indian Contract Act, 1872, facilitates trust in transactions by involving a surety who undertakes to fulfill a debtor's obligation upon default. The surety's role, while secondary, comes with significant rights to protect their interests against the principal debtor, creditor, and co-sureties. These rights, enshrined in the Act, balance the surety's obligations with remedies, making them a critical study area in contract law. All payments rightfully made. This implied right ensures the surety is not out of pocket for fulfilling the debtor's obligation. Right of subrogation. After payment, the surety steps into the debtor's shoes, inheriting all remedies the debtor had against third parties related to the debt. Again, right to securities. Section 141. The surety is entitled to the benefit of any securities the creditor holds from the debtor, obtained before or after the guarantee, upon discharging the debt. Right to set off. The surety can use any set-off or counterclaim the debtor could have raised against the creditor. Against co-sureties. Right to contribution. Section 146. If multiple sureties guarantee the same debt and one pays more than their share, they can demand contribution from co-sureties in proportion to their liability, equal unless otherwise agreed. Release of co-surety. Section 138. If the creditor releases one co-surety, others remain liable but can adjust their contribution rights accordingly. Sections of 126. Definition of Pawnor Limited, 2006. Facts. A surety paid off a loan after the debtor defaulted and sought indemnity from the debtor. Decision. The court affirmed the surety's right under Section 145 to recover all sums paid, emphasizing the implied indemnity contract. Explanation. This ruling underscores the surety's primary remedy against the debtor, ensuring financial recovery post-payment. It illustrates the practical application of indemnity rights, balancing the surety's secondary liability with reimbursement assurances. Amrit Lal Govardhan Lalan V. State Bank of Travancore, 1968. Facts. One of 3 co-sureties paid the entire debt and sued the others for contribution. Decision. The court held that under Section 146, co-sureties must contribute equally unless otherwise agreed, granting the paying surety relief. Explanation. This case clarifies the equitable principle among co-sureties, preventing one from bearing an unfair burden. It demonstrates how Section 146 ensures fairness in multi-surety scenarios, a key right against co-sureties. Bank of Bihar Limited v. Damodar Prasad, 1969. Facts. A surety argued that the creditor's failure to pursue securities reduced their liability. Decision. The Supreme Court ruled that the surety's liability remains coextensive under Section 128, but they can claim securities under Section 141 post-payment. Explanation. This case links the surety's liability with their rights, showing that while they must pay, they retain recourse to securities, balancing obligation with protection. Conclusion. The contract of guarantee, as defined under Section 126, establishes a tripartite framework where the surety's rights serve as a safeguard against their contingent liability. These rights, indemnity from the debtor, access to creditors' securities, and contribution from co-sureties, provide a robust legal shield, ensuring the surety is not unduly penalized for stepping in. Understanding these rights is essential for appreciating the surety's role and the protective mechanisms embedded in the Indian Contract Act, making this a pivotal topic for legal mastery.